This is the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel. It's our May meeting. Uh, I'd like to welcome all of you and ask that we dispense with the uh, introductions, and that if you're going to speak, please then introduce yourself. That would be it's turned out the past few months to be more efficient that way. The one announcement I have is that Rebecca Turner will not be able to make it this evening. But that's about it. Otherwise, I have no announcements. Does anybody have any that they'd like to share? Okay. Then Monica and Robin, I turn it over to you.
Sorry, Aton, I have
Yes.
one thing. This is Lisa. I'm sorry. I had
Okay.
to shut my blinds. I just wanted to thank you for your testimony last week and today for Senate Judiciary and House Judiciary, and you did a great job, and I really appreciate you representing us.
Thank you, Lisa. That's very kind. Thank you very much. Ah, okay. So the Crime Research Group, tonight represented by the Executive Director, Monica Weaver, and you, Robin Joy, are the Chief Data
Director of Research is Rob.
Director of Research. Okay, and they're going to speak with us about the study of pretrial conditions of release, Act 40, Criminal Justice Investments and Trends Report. So, take it over.
Okay. Well, I'll start, and I'm Monica, the executive director of the Crime Research Group. I have met many of you in a previous lifetime. I was a member of the panel, so some of you I certainly have worked with, and others of you are new and I don't know yet, but I'm looking forward to talking with you. And with me again is Dr. Robin Joy, the Director of Research, who is calling in. Some of you might see the little phone signal there on your screen. And so that's Robin. And we're delighted to be with you tonight and to share with you and just have conversation about two of the most recent reports that we have released. And I know that Aton shared links to those reports with you in the agenda. And we also recognize that there's a lot in these reports. And so we look forward to the opportunity of sort of talking to you a little bit more about them, answering any questions you have, and just having discussion in general. So I'm just going to kind of set it up. And the way Robin and I usually do this is I drive, I'll share my screen as we sort of walk through reports, and then Robin will talk through them. Does that sound good for everyone? Okay. So we're going to start with the Act 40 report. And I think a number of you will remember in 2023, this was post-justice reinvestments, more or less. And the legislature was very interested specifically in looking at, it started with the legislature wanting to know, well, is anything happening? Is justice reinvestment making a difference? The report got a little bit bigger than just reinvestment, which look at the criminal justice system, look at trends, and give us very specific data. Act 23 was pretty interesting in terms of reports, in that it prescribed what it wanted us as the Statistical Analysis Center to provide back to them. So you may ask us at some point, why is this not in the report or this not in the report? It's because we were responding to what the legislature specifically told us. And as you will see, it was a lot of information to gather in and of itself. So it was hard to go beyond that, although we certainly had questions. And then that will lead us into a new report we just released on violations of conditions of release. So I'm going to share my screen now, and I'll just start with Act 40. And what I'm showing you here is just our webpage. It's the research roundup page up in the corner here. And the reason I'm bringing you there is because each one of these sections of the report is its own interactive site. And so when you click on, I'm going to click on arrest and clearance rates, and we'll talk a little bit about that. But when you click on these, it brings you to a different page with the report on it, and then you can interact with it. And Robin's going to explain a little bit more about that. So Robin, I have the crime trends and clearance rates page open, and
Okay.
if you want to.
Sure, I will begin.
Start.
So, hello, I'm the voice on the phone. So I'm Dr. Robin Joy, and I'm the Director of Research, and I've been doing this for over 20 years now in the state of Vermont. So I like to say I know where all the data bodies are buried and how to exhume them. I know one thing I do want to, because I'm on an actual phone, I'm not on a cell phone, I'm on a landline, right? And so I can't see any of you. I don't know if you're about to speak, and I don't know if you have any questions. So, Mr. Chair,
I'll keep watch.
however you want to
Yeah,
handle it, just let
I
me
will
know.
too, Robin. Yeah. So.
Yeah. So, with that said, we're going to start with the beginning of the system, the crime trends and clearance rates. As Monica said, that we were kind of limited in what the legislature wanted us to do and how they wanted us to do it. And then also deciding what the best data sources are to help answer some of these questions. And I just want to give a shout out to the Department of Corrections. They gave us a lot of data very quickly that we appreciate the amount of effort that went into getting us that data so that we could meet our deadline. But this data that we're starting with is what's called the National Incident Reporting System. And Vermont is one of the leaders. We've been with the NIBRS system since the 1990s. The reason why we like to use this data set is that it's audited. So each police department has an auditor. There's a state auditor to make sure that the data is being recorded in a way that meets the FBI specifications. NIBRS is now a national data set. That means all the states are moving towards NIBRS, but we've been NIBRS compliant since the 1990s. These data are publicly available. Anyone can download the raw data, and it's a wealth of information. It gives you incident level. So an incident is the response that's what the police respond to. I call the police, they respond, that's an incident. An incident can have multiple offenses. So it gives you every offense that was involved in those incidents. It gives you every person that was involved in those incidents, and the relationship from the person, from the victim, if it's a person crime, to the offender. Was the relationship an intimate partner? Was the relationship an employer? Was the relationship a teacher? It also gives you an information about what property was involved, the amount of property that was involved, whether a weapon was used. It gives you information on the arrestees and what were people arrested for this incident, if there was an incident. If there was an arrest. So it is one of the richest data sets that are available. It also includes demographics of the people who were involved in the offenses as victims or alleged perpetrators. It gives you also, for those that are interested in studying hate crimes, there's a hate crime designation in here, and it goes down to all sorts of detail about what kind of hate was involved in the crime. So again, a wealth of information. We like it so that you can replicate our work. These are publicly available data. It goes back to the 1990s. We tell you not to use 2014 or 2014 to 2016 because that was when the state switched to the Valcor agency and there were some problems in the NIBRS reporting. So don't use those years. But past that, it's fine, and before that, it's fine. And so that's what we did for this part of the report. And you can see, you know, Monica, just kind of scroll down to something so that people can see how they interact. If you do the crime
I'm just at
trends
that
by year, yeah. So you can see here, and these are crimes that are reported to the police, right? So it's not, it's obviously not capturing all the crimes that happen that never get reported. But if you interact with these, you can see how the crime rates increase or decrease over the time, and what broad crime category they are. They're, you know, whether it's drugs and narcotic offenses, or you want to do crimes against people, on whether it's, you know, assault offenses. The way NIBRS is organized or structured, all assaults are covered in that assault category. If we want to find out if it's an intimate partner violence, we have to merge with data within the NIBRS system, and we do this often to get to that victim or offender relationship. So, but for this, we just looked at what the general crime categories were, and then you can see the clearance rates as well, and how many of these crimes end up being cleared by arrest. We give you in each of these pages, we give you policies affecting the data and some definitional issues to be aware of as you're interacting with these data, because the things that the language that we use in Vermont is not necessarily the language that's used nationally. And so the National Incident-Based Reporting System is a way to try to get that language standardized. So there's a list of all the crimes that meet all the Vermont statutes that meet the definition, for example, of kidnapping in the NIBRS data. And one of those is unlawful restraint, which is a very common crime in Vermont. It's often charged with domestic violence cases. So it doesn't necessarily mean what the general public sometimes thinks that kidnapping means, that somebody's being grabbed off the street. It is something else too. So we tell you in these reports some of these ideas. We
Robin,
also
can I
looked
just?
at, yep.
I was just going to let people know and just do a quick little, like, you can see that I've been going up here and kind of changing from the drop down lists, and then you could see the crimes changing on the side here. Same with this one. If you change this drop down list from crimes against people to crimes against property, this graph will change and the list of crimes will change. And you can also sort on these columns. I just wanted to show people that, because this is going to be a very common functionality that you're going to see throughout all of the other reports. Yeah. So, okay. Sorry, Robin, go ahead. Yep.
That's okay. And so we also looked at arrest types. And here again, this is something you guys, you know, it's reading and understanding how the difference between the FBI and the CRG, the FBI in Vermont, identify arrest types. But what we draw this panel's attention to are some of the differences in arrest type by race category, on whether somebody was arrested, cited, or arrested on a warrant. And again, the NIBRS categories don't necessarily meet up nicely with the way that Vermont does things, and how a individual officer on the street views a citation and how that gets coded sometimes gets a little messy. But there are consequences. There are more negative consequences to being physically arrested, brought down to the station, arrested on a warrant, than there are for being cited to appear. And what we kind of looked at was that Black people overall were more likely than other races to be arrested on a warrant, and that Black individuals who were arrested were less likely to receive a citation compared to those of other racial groups. The best practices for this data are to use the self-identified race, and that is because that's what the the FBI requires. Whether or not this part, right? So if I get arrested and I've been arrested 10 times and they know me, are they asking me my race and, every time they arrest me? Probably not. So it could be that my race is in Valcor and nobody bothers. They look at the race that's there and they don't bother to, check up on it. I think that this is an area that we've been asked about a lot, and departments have told us different things over the years. That this is an area, especially Monica tells me that some of the division are here. There's that data quality analysis that we wrote about in the report for the division, and going through and working through that process with departments, I think would be very interesting. And so then, what we also did here is, if you scroll all the way down to the bottom, you'll see a version history. We're telling you what we changed, and I'm not. If I change a typo, which we find, I'm not writing that. But if I change something substantive, I'm telling you that I changed something substantive. And then you find at the bottom, so you don't have to keep going back to our website, all the different, all the other reports in this Act 40 report. So I'm going to stop there, take a sip of my water, and see how people are doing.
Let me check for questions, if any.
I have a question, Eitan. It's Lisa.
Go for it.
Sorry, I can't find my raise hand.
There you go.
Thank you, Monica and Robin. My name's Lisa Ryan, she, her pronouns. I am the Community Inclusion Director at the Vermont Criminal Justice Council. So I work at the Vermont Police Academy. We're responsible for training and certified all law enforcement in the state of Vermont. And I just wanted to either clarify or maybe just, this is just a comment, but I think Robin, you had mentioned about people self-identifying for their race and things like traffic stops or when there's an interaction. And
no, only just for, let me just clarify that for a second. It's when you get fingerprinted. It's that very specific part.
Okay. Thank you. I must have missed that. I was like, well,
no, I didn't say that clearly.
I don't think that's happening from my knowledge. I'm pretty sure that it's perceived upon the officer. So
right,
okay.
because these data are once a person, these are arrests, and so it goes to this other level where there's more interaction, and then there's information being exchanged that.
Right.
Well, as Robin said, fingerprints.
And so when it comes to the offender race or the victim race in these data, right, that is probably often observed race. And then, it's again, for folks that have a lot of interactions with the police, it's kind of hard to say which came first, the entry in Valcor with your race attached. Right. Do you understand what I'm saying?
Yep.
But for arrest, for arrest, we should be asking, because this is your fingerprinted record, and that's what the FBI requires.
Okay, thank you for that clarification. I'm
sorry,
I misunderstood.
Thank you.
Thanks.
Yeah, really important.
Yes.
Are there other?
So I was going to. Okay.
No, I don't see any other questions. I was going to move ahead too, Robin. You want me to?
Yeah, bail and detention.
Bail. So we're going to go to bail and detention, another lively topic of discussion, usually among groups. So just wait for this to load. Okay, so here we are on the bail and pretrial detention page. So.
All right. So here we got an extract from Odyssey, which is the case management system for the judiciary. I think it's now technically called Enterprise Justice or something like that.
Correct.
Yes. So when the judiciary moved to this new system, they got a lot of functionality that didn't exist in the old system that was called VTADS. We have been getting extracts from VTADS for 20 some odd years, almost 30 years for the entire agency. We still get the same extracts from Odyssey. What we're able to do, though, now is work with the judiciary through their MOU process to get extra data that's not included in our regular transmissions from them. And we worked with them to get data on bail, and some of this data we're still not able to use because we're working with the judiciary to understand what they gave us. One of the things we were supposed to do is find out who was able to pay bail, and that is the answer. That's the question we still can't answer, and that we're still working on with the judiciary to be able to answer that. But what they were able to do was to give us what kind of bond was there, and then also we were able to do some counting the bail amounts. So we used two data sets for this, and and then we used DOC data as well. So bail is tricky. So as you know, it's one of those high impact, high decision making, high decision influence that you are concerned about as the panel. Bail changes over time. There's the bail at arraignment. There's bail that happens in between. There's bail at the end. For some of this, we were able to use the bail at the end because we haven't really had a discussion with stakeholders yet about which bail do you want? Which bail is really the bail that you're concerned about, and that you want us to begin to measure how people are acting through the system. So using the data that we generally get from the court, we did an analysis of bail status at disposition. And so you can see as you go through these that there are some county differences, that there are some gender and race differences, and none of this stuff that we've talked about and we've published in other reports. So none of that is actually too terribly new for us, but it may be new for you seeing it. And then we looked at bail data, the amount of bail that was there, and you can kind of play around by the offense type and what you see. Look at the again, the devil is in data is always in the words as well. So if a person has a DUI and a domestic, they're going to appear in some of these tables twice, depending on how you want to look at the data. And so we tell you that, but we just want you to be aware. Overall, Black and Asian defendants had a higher percentage of bail set over $5,000 than white defendants in felony cases. We need to understand more about the disparity. There was not a disparity when violence was charged, but overall there was a disparity.
So this,
Monica, yeah, go on.
Oh no, I was just I skipped around a lot, like you could see, and I just wanted to again point out here, I do think on this report, the introduction is a really critical piece to this report because we talk about the bail laws in Vermont. And then when you get to the analysis of the judiciary data, there's good descriptions of the types of bonds that we're looking at because they are very different. So, we weren't going to go through all of that, but I just wanted to point out, I think these are really important parts of the report for you to look at in order to understand all the information.
Okay.
Anyway, Robin, I'm back now to bail amounts by race. So
that's okay. If you go down to analysis of DOC data.
Yeah. I'm there.
Yeah. So part of this is looking at, bail is also a complicated subject matter because people don't just commit a crime or get arraigned for a crime and then not get arraigned for another crime until it's not a step. I don't commit a crime, get arraigned, and then wait till I commit another crime or until I get arrested again. So people are moving in and out of the system a lot of times in almost like a zigzaggy pattern. And I can get bail. Let's say I get bail on a petty larceny, and the bail is $2, and I can afford that bail. However, I have another case where I'm held without bail, I'm not going to pay the bail on the $2 because I'm not getting out.
Right.
And so it's kind of digging down and beginning to understand, especially when we look at how long people are held, the length of stay. It really is, if you go down distribution by person and detention duration. So the one I have up, Monica, is violations of conditions of release.
Yep. Okay,
And we
that's
have
the one I have.
one person. So we have a person who is held for 2,361 days for want of bail on the violations of conditions of release. My guess is that there were other charges that that person had that maybe had no bail. And so it's hard to tease that out in the data in the time that we had to do this. So we got the data, I think, in July, and I had to have this done by October. So we didn't have the time to tease it out as much as we wanted to. But now that the data has, now that the basics have been done, should the federal government decide to fund research, we would be able to do a little bit more in depth on this. To understand really that intersection between people who are being held on another bail, or it's a very high bail amount, and these low bail charges.
On the other hand, you can also see over here on the how many people are held 1 day or less.
Right.
So I mean, it's just
that
interesting to and see how most people are really.
Yes, but that 1 day can be very detrimental to somebody's life.
Extremely.
And that's one of the questions, I think, for this group and for stakeholders is, what are we doing going through the process of bringing me to jail, going through all of the intake that has to happen to make sure that, I'm not going through withdrawal and I'm not suicidal, only to release me within 12 hours. What public safety has been achieved by that? Those are some questions, especially given how detrimental 12 hours in jail could be to somebody, or 24 hours in jail, and to somebody's success on the outside, especially since at this point you are not guilty of a crime, right? So there were some version histories here. We updated some issues that we identified in Addison County with the judiciary, and then we had some conversations with our partners and edited some clarity. And I'm going to stop.
Yep. Questions, thoughts?
Are there any questions?
I'm thinking. I don't see any yet.
Okay.
I don't see any. It's, as we know, it's a lot. Yeah.
It's a lot.
I will show you one thing. Now there's a bunch of different ways. You can obviously communicate with us. But if you're in this report and you forget who we are, if you go up under author prepared by Crime Research Group, that will just link you to an email address. If you click on this and you'll be like, hey, I have a question about this report, and we will get it.
Okay.
Yeah. So, and again, I didn't really show you, but hopefully you saw me, as you can just, pop around to the different sections of the report here on the screen. You have a question, Nathan?
I would be interested. What did the legislature do with this?
Well,
I mean,
let's see.
I'm interested in the reactions.
Yeah.
And,
So we were able to go the Joint Justice Oversight Committee. That was, I think, was in December, prior to the start of the session, and we were able to preview the report with them. Again, as you can see, there's a lot of information, so we just kind of walked them through how to do it in the highlights. We were asked to go testify at in House Judiciary. We got through part of it. We didn't get through all of it. And, in full honestly, I would say I'm not sure they did anything with it.
Okay. I was just curious to know what their reaction was, because it seems like it's just an extraordinary tool that we've been all of us have been sort of talking about for rather a
Yeah.
while. Yeah.
I mean, it truly is. I mean, this was a really interesting project for us, and a culmination of a lot of different data sources. And you know, we're talking about judiciary data here, corrections data, but as you get into other reports, you can see we've put information in here from all of the like diversion and community justice programs. There's transitional housing information in here, really all in one place, which I think was the desire
Right.
of the legislature for a very long time. And so it's our hope that
Yeah,
people
and
will
I
still
think
be looking to this.
Sure. Yeah.
yeah. So there were a few parts that are left on this. One is you know, there was some discussion in the legislature this year about the definition of recidivism.
Right.
The definition of recidivism is something that DOC has to calculate. We have always ignored it because it's not based on the literature for what we do necessarily.
Mhm.
But there was also a discussion of measuring desistance, and we did convene a work group of stakeholders to try to figure out how to measure desistance and to begin to look at that. We did set up a process with the Department of Labor so that we could look at a cohort of folks and see and match them into their data, into the Department of Labor data, and get a sense of employment after incarceration or employment, you know, in general. And with a big asterisk that the employment data that's reported to the Department of Labor is going to miss a lot of folks. But we just wanted to make that bridge. And so we've made the bridge with the Department of Labor. We know the process to get the data, and we know roughly the cost to get the data. The issue becomes whether or not the federal government releases these funds next year.
Yeah, because as you can see on the top, the big green part there, the Bureau of Justice Statistics actually paid for the work that we did. So while the legislature required the report, the Bureau of Justice Statistics paid for it, which was really, you know, very, very helpful. And we were able to, you know, receive this money because of our designation as the Statistical Analysis Center, but we still have to apply for it and have them approve
Right.
the work.
Right.
And so the issue with the Department of Labor data is Act 23 wanted this report in 2024. It also says we're supposed to submit a second report in 2027. However, at this point, there is no funding for us to do a follow-up report and to continue working to be able to access the Department of Labor data, which we think would be really, really fascinating. And we're excited to be able to do that. It would be a whole new data set that you know, we haven't been able to work with in before.
Right. Okay.
Yeah, one of the things we usually use these funds for is to build bridges to get the data and then to do the preliminary coding so that, you know, the next time somebody wants us to do, you know, analysis with labor data, we've done all the heavy lifting, and now it's easier and cheaper to do it. But
Right.
yeah. So what we were
Okay.
going to do next, because we're starting with bail. Now, there are all these other things that are here. We're happy to talk about any of them as you go through them. You know, I think actually, no, that's it.
Okay.
What we're going to do now is switch to the new report that was on the violations of conditions of release.
Can you see my page now? Does it say a study of pretrial conditions of
It
release on your
does.
page?
Yes,
Yeah.
it
Okay.
does.
Perfect. Okay. So similar to this, we just have a homepage here. This is all one full report. So just click here and open it. So I have it ready to go for you, Robin.
Okay. So a few caveats on how this study came to be. This was part of, this is two things. One is that there was a subcommittee of the Sentencing Commission that was interested in violations of conditions of release. And because of the switch to Odyssey, we were able to get, the actual text of the conditions in an analyzable format. And Judge Grierson, who used to sit on your committee and was on the Sentencing Committee, he helped write the grant for that. And it was also part of, especially for members of the public who may not be aware, violations of conditions of release is the most common crime in our criminal justice system by like 5 times. And this has always amazed me that it's, we have on this report, I'm on our webpage, let me go back to the report. I think I put it right there on the report.
You did, Robin, yeah.
Because it just has always, amazed me that if you look at our top 5 charges disposed, violations of conditions of release and driving license suspended, that's the DLS number 1, those are basically regulatory crimes, right? They are, I can't commit a violation of condition of release because I'm not on a condition. A DLS because I have a valid license right now. So these are, if they were juvenile offenses, we'd kind of call them status offenses. But you can see that purple line, right, is the violations of conditions of release.
Right.
And the next one, I didn't make that one interactive. I'll have to fix that.
No, that's okay.
And the next one is, misdemeanor retail theft. And there's a big gap there. And part of that is also, there was a famous case out of Bennington County 15 years ago that had 300 counts of violations of conditions of release on one docket. And that's because the person who was charged with those 300 counts was required to go to the police department to blow into the breathalyzer twice a day. He did not. And every time he did not, they charged him with another violation of condition of release. So that's how you end up with 300 charges. This has been something that stakeholders have been interested in for a long time. So we were happy that we were finally kind of able to look at what the actual data requirements are, what the conditions are, who's getting them, and what makes a difference here. Now, the judiciary has like some standard conditions of release: come to court, update your address, stay away from people, don't abuse people. These are, you can't just assign all of these conditions to somebody. There has to be some nexus between the condition that you're imposing on a person who's just charged and is still technically, innocent, and the crime or the person. We used a few things. There were a lot of non-standard conditions entered as free text. And so we did some text analysis to categorize as many of those as we could into some broad categories. Some of them were very, very specific and not really a condition of release, such as they were allowing the defendant to, it would say something like the sheriff's department can transport the defendant to so-and-so to get their clothing and then transport them somewhere else, right? So there were very specific orders that were helpful to the defendant and not anything that they would be able to violate either. Now, a few things about, so you can go through and see all of these conditions that were given in particular cases and by crime category and by, you can go either way, right? On, no contact. You want to look at fish and game offenses, or do you want to look at motor vehicle offenses, and you can see what conditions are ordered there, or you can go down to, if you want to see who has no contact, well, no surprise there, like domestic assaults are the ones that have the highest no contact. There were, Chittenden, is obviously the largest population in the busiest criminal court, but they weren't necessarily the largest. They didn't always have number one. They weren't always number one with the number of cases that had a particular, so there's county differences. Washington County has the most cases with no abuse and substance use mental health screening conditions. Chittenden did have the most cases where the defendant could be released to the custody of another, and this is a very, the law has changed a bit. We got these data, and we talk about that. However, Orleans County had the second highest of people who were released to the custody of another. We did look into, after conversation with the state's attorneys, look into why Orleans County had that particular condition, and I should probably write that up there too. These were largely in active domestic violence cases, which would make sense for that condition. But still understanding why that county, and it could be that there's a lack of available resources for people in that county related to domestic violence. You know, it does need more research. So then what we did is we looked at, so conditions are supposed to do two things: protect the public and make sure that you appear. The overall failure to appear rate for the cohort was 15.7%. And the failure to appear rate in this case is measured by whether or not it shows up on the criminal histories. And the only way it shows up on the criminal histories is if a warrant is issued by the judge. And so that's how it shows up in the court data. There was no other way to get that. It should be, when we spot check dockets and we go in and we look at the dockets and what are we missing or what are we capturing, I can tell you that there are judges that'll say on the record, oh, so-and-so didn't come in today. We're not going to issue the warrants. You know, he'll be in tomorrow for another case, or we'll see him next week. Don't worry about it. You'll see these in the docket, that kind of, you know, grace period. So we don't know that, we don't know how that's being used and who, and, you know, are all people benefiting equally? Probably not. But I do want you to know that that's a limitation, that it's only, you know, when the warrant is issued. And some people had more than one failure to appear during their case, and that is, you know, interesting as well. So the people with the highest failure to there we go. The people with the highest failure to appear rate were actually people who were told not to leave the state. So I just thought that was kind of amusing. I assume that they did. Lamoille County had the highest failure to appear rate at 20.38%, followed by Caledonia and Washington, and Orleans had the lowest. So you can see those rates by county. So again, there are these county differences. And then we moved on to a regression analysis, and we did a lot of regression analyses here, and it's just basically what is influencing, you know, what's statistically significant in predicting, and these were generally logistic regression, which talks about log odds and all sorts of other stuff, but these are the things that you want to look at, right? To say, all right, if all things are being equal, if I had a male and a female, and they had the exact same criminal history, they were in the exact same, you know, charged with the exact same things, and in the same county, the female, the woman, was more likely to have a failure to appear than the male. And so, you know, we hypothesized that this could be because of, you know, gendered societal expectations that are preventing, you know, women from accessing, you know, getting to court on time or being there. You know, it's something that needs more analysis, obviously, but we pointed out in none of these were race a statistically significant factor in failure to appear or in new crimes or in violations of conditions of release. And so what that tells us is that we know from the other report, right, that the racism is creeping into who there's the racial disparity and who's getting conditions and who's not being released, right. And that you know, we'll talk about some other things in a bit, but race was not a predictive factor here. Okay. And you can see here, we also did a control group of people who were released on their own recognizance during the study period, right? Because that's one of the questions. Do conditions do any better than ROR?
People
And
released
the
on
answer
their
is
own.
no. Yeah,
Oh,
people released on their own recognizance. And the answer is no. So again, all things being equal, same criminal history, same charges, same county, people who were released on conditions had a higher likelihood of failure to appear. Now, this could mean a few things, that there's something that's not being captured, and that's being captured within the courtroom work group. So we know, for example, that stable housing is a contributor to failure to appear. So like if you have stable housing, you're more likely to appear. If you have transportation and access to transportation, you're more likely to appear. So there may be something else there, or it could be that you're being overly, it's not in this case that you're being watched, that'll be the next one, but the system has come down and said you're not reliable, and so now you're kind of self-fulfilling that prophecy. But this is, again, one of those high-risk, high-impact decision-making processes. And the answer to this, and so Monica can put in the chat another study that we did on a pretrial release screening tool. So when you have these high impact, high discretion points in the system, one of the profession's answer has been do a risk assessment that removes the discretion, right? You're going to fill out this form and you're going to, this is the score, and then we're going to tell you that this is what is supposed to happen.
oh,
When, yeah, well, so
that
way
could have
back
some problems.
it does. So when in like 2015 or so, and Monica will have to help me with the dates, there was pretrial services was stood up by the legislature and was housed in the Department of Corrections. And what happened is that everybody, so the Department of Corrections contracted with the community justice centers, and the community justice centers had pretrial monitors that would go to folks who were either incarcerated or at risk of being incarcerated pretrial and do something called the ORAS risk assessment. The ORAS risk assessment that they were using, and ORAS stands for Ohio Risk Assessment. There's a whole suite of tools. DOC uses some of them still. They've had them validated, et cetera. But the ORAS that the pretrial services were using at the time, this is again about 10 years ago, relied on a few things: an interview and criminal history. And because the criminal histories are actually terribly difficult for people to access, they should be. Because of who they were, they couldn't access the out-of-state criminal histories. Right? They could only access Vermont criminal histories, and they completed the score based on that. That turned out to be disastrous because a lot of people do have out-of-state criminal histories. The other tool, and this is the one that we tested, was the Arnold assessment. And this was billed as being better because, and not by us, but by Arnold, because it didn't require an interview. However, it still required criminal histories. And for this study, that we were able to access as researchers the out-of-state criminal histories. And what we found was that about 40% of people that were in the cohort had an out-of-state criminal history, mostly from New Hampshire. And we also found that this tool didn't work. And I think this is, where your group, where this panel can really take a kind of lead on understanding the policy and what some of the options are. Let's just say hypothetically it did work, that it did accurately predict who was likely to failure to appear, who was accurately likely to commit a new crime, et cetera, et cetera. It's still based on the criminal histories. And criminal histories are just an accurate representation, and they're generally accurate, representation of what the government did to somebody. We arrested this person on this date and we charged them with this crime. We filed in court on this date and we charged them with these crimes. We disposed on this date. We did this, we did that. It is an accurate representation of that. It is not an accurate representation of the person's culpability, right? Because we know that people plead guilty to things that maybe that wasn't exactly what they did, but they're pleading guilty to get out that weekend. All of the racism that you have documented is baked into the criminal histories. So you're using the records of a racist system to get a result that is also equally going to be racist. And this is a problem with continuing, I think, and we've argued this before, of continuing to use criminal histories in the administration of justice and figuring out how best to do that and when they can be used. So we talk about that. We talk about some work that other scholars have done looking at especially, these pretrial risk assessments and use of criminal histories and how the racism plays into that. So, it is this interesting thing that here's this decision-making process. The tools that this profession have come up with are as problematic as the free reign, I think.
Right.
I don't have an answer. I just.
Right. Eitan, just wanted to check in because we've got like 5 minutes before 7. So you want us to wrap up in 5 minutes? That'll
If you
help
could.
us. Yeah. Okay. So Robin, what are some other of the main points around this, the violations of conditions of release?
Yeah, so most people aren't committing new crimes while they're out on conditions. I think that a lot of times the stakeholders focus on the people who are constantly in the system. Most people aren't committing new crimes. Most people aren't. So I think that is, policy doesn't just have to happen in the margins where the resources are being used. It's also stepping back and understanding, well, what are making people successful, and understanding that. But we do need to look at why conditions still make a difference so they make a difference in whether or not somebody commits a new crime, and they make a difference in whether somebody fails to appear. So understanding that a little bit better. Because this is the first time that we've gotten these data, and again, we usually are working on these really tight deadlines, we didn't map out how conditions change over time. And I think that's an interesting question. We were also interested in those folks that just got 2 conditions. They just got, show up to court and
update your address.
Of your address.
Yeah.
Yeah. And again, like arresting somebody and bringing them to a facility for 12 hours, it's kind of like, why are we doing that? And part of it is, what stakeholders told us was that, there was probably a lot of conditions and the state's attorney didn't get any of them, and this is just what was left. But you were now setting up somebody to theoretically be charged with a crime for not coming to court, right? So it's creating a difference that could be abused. We don't know whether it's being abused. We can't tell that from the data, but we do want to say it. And these conditions weren't indicative of any, like they weren't predictive. Those 2 conditions, people who had those 2 conditions weren't predictive of anything. But so that was that. That was that.
So yeah, we did a lot of summary here at the end in terms of our findings and further ideas. So again, it's a meaty report. It's a lot to sort of dive into in a short period of time. So again, if you're reading it and you're thinking, I need to have some things clarified, by all means, reach out to us. And I did put the other study in the chat, which is the one related to the pretrial risk assessment. So you can have the link to that report there.
Eitan, you're muted.
Oh yeah, I can't hear you, Eitan.
I said I wasn't going to do that, and then I did it.
We all do it.
It just there's going to be enough here that, in fact, something like the RDAP can use for the production of the reports that we are biennially required to make, correct?
Are you asking us? Or are you asking
Yeah.
the group?
Yeah, no, that was an
I mean,
ask.
I would think so. Yeah, I would think that, I mean, the whole point of all of these reports is to put them out there to help
Right.
inform, other people's work. And so, particularly when I think about the Act 40 report or any of our reports that overlap with the RDAP work, you can
Okay.
use them and cite them. I mean, we've seen people doing that already this legislative session. They have looked at the report and cited the report in their reports or in other testimony.
Our
Okay.
only request is that if you are going to use our work, and you're kind of paraphrasing, double check with us to make sure the sentence that you're using is correct. So I do this a
Okay.
lot with folks. Like, I'm going to give you data, and then I'm going to tell you what you can say about this data and what you can't say about the data.
Yeah.
And sometimes what happens is people see things and they say things about the data that they can't really say, because that's not what it's saying.
Okay.
And we're happy to do that. Like, you're not bothering us if you do that.
Oh,
No,
great.
no, no. Yeah.
Good.
Yeah.
Any other questions from anyone? I think not. I am very excited at yet another tool myself
I just
to be
Right.
able.
I just have some thoughts. I don't know if I have questions.
Oh, well, Sheila?
Thank you everybody. Sheila Linton, she, her pronouns, panel member. I sorry I'm off camera. I can put myself on camera, but I'm like on a laptop in a car, but in a yard, and I'm just just trying to let the sun kiss my face before it completely goes down. So Monica, thank you for this presentation. It was really in depth and I really appreciate it. It was a lot. And so I'm processing it. But what I'm sort of curious about is from this report, are we looking as an RDAP to give feedback about this report? Are you looking for feedback? Are you looking for some of those questions or ideas or thoughts that you had that you even mentioned while speaking? Like, you talked about some barriers that people might have to showing up in court. And I thought to myself, like, immediately, like, well, do we ever ask them? Like, do we ever ask people, do you have barriers to showing up at court? Like, just when you go to court, just something
Right.
as simple as that, and being like, yes, I'm a single parent and I don't have childcare. Yes, I'm low income and I don't have a car and there's no bus to the courthouse. Yes, I'm working during that time and I can't because I'll lose my job. Like those are three things off the top of my head that so I'm just sort of curious. Like I hear these reports and then it's like, yes, I love the assumptions, like, okay, is it transportation, is it this, is it that? But rather than I I think I see it progressing. But yeah, I'm just wondering, is that the progression to get to the point to actually ask those questions and actually to put some type of system in place that actually addresses even the questions that you had within your presentation? And if so, is that's the RDAP's place, or are we just taking in this information? Because I'm like, again, I'm still processing, but I have a whole
Yeah.
visions and thoughts that
Yeah.
I just think maybe are common sense that people have already thought of. Like,
Well, I think so. We both have, I'm sure, some ideas about this. And so I'll just start like with the Act 40 report. I think it would be fabulous if people started to talk about it more and ask questions in different settings, in this setting. Our role, Robin does a much better job explaining this, so as researchers, is to bring this information forward. And oftentimes we just come up with more questions than answers. And oftentimes need to come up with a whole nother study get more money to do the research. But a lot of times what we put out here is for other people to digest and discuss and think about how they might want to respond to. Robin, say that in a better way.
Yeah, no, I think that's it. You know, we can, we walk a very fine line as researchers, right? And so here's what we're finding. I don't know whether you're always the right body, whether RDAP is the right body. I think that, yeah. I'm conscious, you know, certainly of what the chair has testified to over the last week, and you know, and today, and how much is put on you guys. But I think that there are some really, you know, on your point, Sheila, about is anyone asking these questions? You know, one of the things this study was done, the time period included some COVID, you know, backlogs and so on and so forth. So really, we'd like to do this again some other time. When there weren't the COVID backlogs. But one question you could ask the judiciary is, and I think that they would have this data, how have failure to appears, you know, gone down since we moved to phone hearings? And is this helping anyone? I don't know the answer to that, and I don't know the mechanics of it. But I think that, you know, those are some questions that stakeholders can ask. And I leave stakeholders being broad, whether it's you, the legislature, community groups. We're happy to say the data that we have, the research that we have done supports asking these questions. I think we can do that.
Okay.
Thank you. And though why I appreciate a good presentation that comes from some surveying and all of that collection, it's like sometimes I feel like we've already have the answers right here, like maybe even with this group. I know I have a lot of experience with law enforcement. So I feel like the studies have already been done. Like I feel like the surveys are right here. I feel like it's like a meeting, a focus group. Like maybe I'm a little out of it. I don't know, but I feel like everything is so complicated and overcomplicated for unnecessary reasons. And I say that out of super respect for the work that's being done and really informative and glad that we're able to get grants and monies to fund this, to be able to have this information. And I think there's just maybe other ways of going about it to, you know, get more to the questions that I feel like we keep on asking over like decades.
Well, and Sheila, I think, you know, we agree with you on this idea of, and you know, you and I had a conversation a while ago about talking to people, and really trying to document experiences. And that's a whole nother area, I mean, of research. I know you're saying, oh, you know, it should be easy to do. And in some cases it is. For researchers, it's a little bit harder because we have to go through all of these steps to protect people. But there is that synergy between those things. And it doesn't always have to be a research organization like us having those types of conversations with people. You can take the work that we've done and pair it with other work and conversations that other people have gathered or that you gathered, to you know, to really make it a really full picture, I think, if that made sense.
Yeah, I appreciate that, Monica. Thank you.
Yeah.
Okay. Anybody else? I am guessing not. Thank you both enormously.
Our pleasure. Yeah.
I mean,
Our
this
pleasure
was
as always.
Robin, people are clapping. I just need you to know that because you
right.
can't see them. So I'm just letting Robin know that there's clapping happening.
No,
Wow.
that's wonderful. It will be. I have to spend more time with it because I started going through it, and then I started going through the regression analyses, and I was like, I am slow at this, and I know it, but it's gonna take me a while. But
Yeah, I'll just let you know, Robin had to do a lot of coaching with me on that, some of that stuff too. So.
I
Yeah,
can
and
totally
again,
agree
you
with
know,
Yeah.
you.
all of our stuff, and we're always happy to, you know, share things and help people analyze data. You know, you don't need to reinvent the wheel if I've already done it. You can,
Yeah.
we're happy to share our work. Yeah.
Yeah, we don't want, I mean, it's not like we don't want you to, but right, we all know how scarce resources are, and if there is something that we have already done that it's useful, like
Right,
that's why we exist in our
right.
minds, right? To help support this system, to help inform, you know, policy discussions, and that's what we, you know, particularly these two most recent reports. I mean, all of them do, but these are the most
Sure.
recent ones. So, yeah.
Great. Well, thank you both.
Thank
An
you.
enormous
Pleasure.
thank you.
Okay.
We'll
Bye-bye.
make ourselves quiet now.
Oh, okay. Yeah, sure. Okay. I wanted to give you an update on the testimony that I've given over the past I don't know how many days, but it's less than a week. Um it went well, everyone. I really feel like it went very well. I was taken by everyone's attention more on talking to Senate Judiciary than I was with House, I must say. But I felt that people really listened well, took the points well. Some people came up with some alternate, some ideas, frankly, about what we might do to facilitate getting past this problem that we seem to have. Um, House Judiciary was particularly concerned because it's not written into the statute. I don't know that the person who was looking at the right statute because it wasn't in the enabling statute. It was in a different place. That was written much later. And so my concern was that I need to look into it some more, but that's not really the question. The point is that everyone had asked us to do this. It had been brought up by several legislators, and we all thought it was a fine idea, and on we are. But here we are also with the problems that we're presently experiencing. Um, I did get a very strong sense from House Judiciary this afternoon that they are interested in a kind of meeting where we, or as many of us as there wants to be, maybe it's a subcommittee again, sit down with the legislators and anybody else who's really a stakeholder in this to get a conversation going about what is finally a systemic problem that is, I mean, it's initially rooted in the fact that the RDAP meets for 2 hours a month and the legislature is part-time. That makes this just, as you can see, rather unbearable. Those are That's kind of a rough idea of how the testimony went. I was told, and I can't find where I put it. This was like a couple hours ago. I'll figure it out. About the desire of Senate, I think, Judiciary to have us come in. Well, they want us to look at other bills, and we'll talk. Which is it? The one I sent you, S87. And then there's another one that I got this email about a few hours ago, which was, oh God, wish I could find the email or if it was an email. Anyway, um, I think H11 sticks in my head or something. I'm not sure. But I'll go back and look. And they want that testimony on Thursday morning at 9, which I can't do. I've already got that booked in and can't do it. I can't even change what I have in there. I would otherwise. But I would do that otherwise only if people felt like they wanted to weigh in on S87, and I'll get this other one to you as soon as I can find it after our meeting. And I need to know, though, if people are interested in doing the reading. It's a 7-page bill. There are 2 pages of amendments to it. It's not very, very long, but I also realize this is very last minute. And I conveyed that to the legislative assistant, who understood certainly. But I'm not going to make a decision without you guys. So I kind of need to hear where you're all at about doing these. I mean, the one for S87 is Todd, do you remember when that one is, when I'm supposed to do it? No, you don't. All
I
right.
don't, but I can look it up. And I think the other one's probably S12 because I know they wanted testimony on that.
Oh, okay. I got the
Thursday
number one
morning.
off. Right.
Yeah.
But oh, tomorrow.
Is
S87.
S87 tomorrow?
Yeah. And again, I know that this is very last minute. I was asked. I may have my own response to that, but I'm only one of us. So, I really want to hear what the panel has to say about this.
Let's say they are set of issues on the left hand side. Like each data point represent a.
I'm sorry?
What will our cluster?
You're being cut off.
I think that was just background chatter. Carry on.
Okay. Okay. Never. Thank you. So if anyone has, I kind of need an opinion. Let's start here then. How many people, and be honest, how many people were able to read S87 before this meeting? Okay. So we're talking 4. What, in your judgment, Todd, how many would we need to have to present? 4 doesn't seem like the panel to me.
I think, do we have 9 panel members here? Or is it 8? I mean, if you want to go by the book, I think it's a majority of the individuals here.
Give me a moment.
My count has us at, let's see, Tyler, Dan, me, Susanna,
8.
Jeff, Sheila, you, Lisa, Grant. Is that 9?
Oh, maybe I didn't count.
Did you count you?
Yeah, I did. I thought 1, 2, 3,
Tyler, Dan, me, Susanna,
4,
Jeff, Sheila.
5, 6, 7. I have 8.
Oh, well, maybe I'm miscounting.
4 isn't it?
Yeah.
And what I'm thinking here, and I guess you all will know this, right, is that if it's that few, and for even counting the people who are here, if it's split, then I'm assuming one thing is that you have to read it, right? And you haven't had time, and that's not a criticism. Really isn't. I simply had a late therapist and was able to do it. But 4 doesn't seem like enough to me. If it's split in half, you you know, half of us have read it, half of us haven't. That doesn't work. So that's fine. It means what I can do is write back and go, and just say it came very late in the game. Very few of the panel were able to read it. We're sorry. This is kind of what have been talking about as being the central problem that we need to deal with. So I can certainly do that. I don't have a problem with that. Do other people think that's a good idea, though? That's an answer. Grant does.
I think I think characterizing it in the way that I anticipate you will, which is this is the structural problem.
Right.
Because
Exactly.
we don't want to come across as saying, yeah, you asked us, but you can't ask us like, we don't want to get
No, no,
that
no, no,
tit
no,
for
no,
tat.
no. I'm going to make it much more in depth than that. Yeah. So, folks, we could demonstrate by a show of thumbs or hands how many people want me just to respond, this is a structural problem. This is what we've testified about now twice in less than a week, not to mention previous years. Um, and we're not going to be able to do this. People have made a good faith effort, but that's not it. That's what I would write, basically. Okay, two of us. Sheila, Lisa. Okay, great. Then that answers that. Um, if it is indeed S12, oh, questions or we just have hands up? Yeah, we do. Sorry, it's me. Um, I don't get this new version of whatever it is, Zoom. It makes me angry. Um, and then I'm gonna ask about the one I don't know about, which I literally got it at 4:30. I mean, it was really that late in the game that I got it. Can I see if it is it Todd or there you are. Can you tell me S12
Yeah,
what it
that's sealing and expungement. Susanna can also speak to it because ORE,
okay.
right? You guys testified on this one too.
Right. And they whoever wrote me the email said ORE had and the ACLU had.
Defender General, I think it will, if they haven't already, AGO, state's attorneys.
Okay. Um I guess I'm feeling a similar thing here that adding what? A day. In other words, you'd have to read it and process it in a day and what? Get back to me within that day? This is insane. All right, I'm just saying it out loud now because I'm just like getting it. It's insane. Or at least that's my opinion.
If
Again,
we're doing anything that's of value, we shouldn't be asked to do it in a rush.
exactly. Very well said, Grant. I love that. I'm going to quote you in the letter that I come up with or the email response. Um, I will copy all of you on the email responses that I send out as soon as I find the email that I lost at 4:30. I know I didn't delete it, so it's good, but I'll respond in those ways. So that's really all I had to say. Um, Todd, do you want to take over presenting about the next item, which is the planning the RDAP's future?
Absolutely.
Okay.
Let me pull up the statute in question. I'm guessing folks didn't probably have a ton of time to take a gander at this, but the thought was with a transition in leadership of the panel, somewhat delayed, thankfully. We had some offline conversations. I should say, had some offline conversations with other folks, just sort of brainstorming around how best to engage in a leadership search for RDAP. And I'm a lawyer, so I was focused on the enabling statute as a starting point. But before turning to that, at least the way we've discussed it, and it's mostly been Eitan and Susanna and me, is sort of thinking about how even though the statute is sort of people get appointed, they either serve as I do and others because of our positions or designated by other positions or because appointed by either the Attorney General or the Director of the Office of Racial Equity. Right. And then the panel elects a chair. We sort of have been thinking about how we can use this more in the way that an independent panel may search, recognizing that we'll have to find candidates that are agreeable to the appointing authorities, but feeling fairly confident we can do that. We mostly wanted to engage this group now with one, kind of grounding ourselves in what RDAP's mission is per the enabling statute, recognizing, as Eitan has already suggested, there's some gloss over that in terms of what is requested of us, either formally or informally from the legislature and other partners. Including sort of a soft call to action from CRG around, well, what are we going to do with this data now that we have it? What further questions should we be asking about this data, and policy recommendations coming therefrom? Looking at all of that and then saying, okay, how do we want to look at ourselves as a group and look towards the leadership that we want to have to guide RDAP forward? So that's kind of my framing of the conversation. I have a kind of weak recommendation or suggestion that we can discuss. But before getting to that, I wanted to at least just take a minute, if folks will, recognizing, we have limited time. Oh my God, man, Zoom has just gotten really complex for me. Okay, can folks see?
Yes.
This is our enabling statute, and organized duties, responsibilities. The top is kind of the preamble. Of note, though, we should be consulting with the HRC, the ACLU, the Police Association, the Sheriff's Association, the Association of Chiefs of Police. Then it's our membership, 5 appointees from the community by the AG, and then a bunch of us who are designees or, in fact, are the named officials. And then 2 members from the ORE. And then I just want to take a minute, the C is kind of the nuts and bolts, who does what, how. D talks about the chair reimbursement. E, again, part of our job, quorum, majority vote of the members present. We got to play with that one just today. And then F is what we're supposed to do in terms of providing recommendations. So I want to just take 1 minute and let folks take a look at these, right? But we're reviewing data that's collected about fair and impartial system of law, providing recommendations to the CJC, the Bar Association, based on social science research and best practices on criminal and juvenile justice and law enforcement, data collection and model trainings, policies, etc., how to recognize and address implicit bias. Providing recommendations to the CJC based on social science research and best practices on data collection and model training on de-escalation. I think this panel, I should say, has done a lot of this in the past. Educating, engaging with communities, businesses, educational institutions, state and local government, and the general public about the scope of racial discrimination in the criminal and juvenile justice system. Monitoring the progress from the 2016 AG Working Group report, and then our regular annual report, biannual report. So let me pause there. That's the essence of the sort of official work. And then, as Eitan said, there's all these other requests and recommendations. And so I just wanted to kind of take a moment to look at that, because it's a lot. It's a lot without the legislative overlay. And I think it's worth considering in this moment of reimagining RDAP what it means to engage in that work, how much of that work we're able to engage in, how we want to lead in those spaces, if there are specific spaces we want to focus on, including weighing in on legislation or seeking broader structural change, as we're trying to do with the short form bill that we have to find out when it gets introduced. So I just want to pause there and see if there are any thoughts, reflections, reactions, and then I'm happy to throw the straw person idea out for further discussion about how we may want to move forward with the leadership transition.
I'll go ahead and share just a thought. I think in reading this, admittedly, I have not looked at the enabling statute in a very long time. And it seems to me that because such an emphasis of our work over the past years have been going towards the development of our legislative report, I think I just let it kind of get into my imagining that our primary responsibility was our interaction with the legislature. And I'm realizing that apart from that report, we don't have an obligation to be doing that work. So I think I'm just or not concrete, not explicit, I should say. So I think I'm recognizing that, and I'm just wondering about, boy, there are some avenues to maybe be engaging in thoughtful conversations over longer periods of time, thus avoiding some of the challenges we have in trying to be kind of a direct conduit from legislators who are trying to pass bills real time, and us being able to match our timelines to them, wondering about how many opportunities are in there. So I'm going to think a little bit more here on these, other numbers of what it is we're supposed to be doing, but I'm just being honest about, I thought we were actually supposed to be working with the legislature more than we were.
Let's put it this way. It was made pretty clear after Justice Reinvestment 2. I mean, I'm not pulling this out of my butt. It was made really clear after Justice Reinvestment 2 that looking over the bills was one of the things that would be new and different that we do.
And in this moment of reimagining, we should be asking for what we want. I mean, those are legislative changes. Part of this conversation is sort of us driving our future, as well as, we can only do what we're enabled to do, but there's no reason, one, to codify that request, and two, to sort of say, are we carrying some of these things out? Should we be carrying some of these things out? Has, not to put Lisa on the spot, but CJC, to what degree are they still looking to us? Do they need to look to us? Should we be reviewing things, et cetera? So again, the goal was just to kind of ground us in that, especially as we look at this leadership moment, but I don't want to slow other comments.
Okay. This is a discussion that I'm not sure I should be running. For obvious reasons, folks.
Yeah.
Because you're going to be going in different places.
So
go ahead.
Yeah, sorry, Sheila's got her hand up.
Sheila.
I want to speak to say something, but every time we have these discussions or presentations, I'm needing so much more time to process.
Right.
And so that's why, I mean, I don't know if that's why other people might be silent, it's like a lot of information and trying to figure out, all things. So I'm not going to say completely everything I'm thinking, but I'm wondering what the statute, what the statute says, but what are we doing now? And so I'm sort of wondering if, sometimes we outgrow statutes or committees or panels or whatever. And what I've been hearing over time, there's been certain needs, there's been certain desires, there's been certain wants, like whether that is for us to look at bills, whether that's for us to testify, whether that's for us to do a variety of different things that we've been talking about, and really don't have the scope or the time. And this sounds like a whole job in and of itself, and it feels like it is. But I'm just wondering if we need to be in another statute, if we need to write another statute for the RDAP to recreate or amend or do something so that we make it what we need it for. And I think, like, Susanna, I'm sorry to call you out, but just in your position too, I'm just thinking, let's make this panel, if we're all investing this energy and time in this for basically nothing, meaning nothing compensation wise, that we might as well be doing it in the efforts of what we actually need. And I think maybe since we've reached this point with the RDAP, and especially before you move on, Aton, and we have our former chair as well, that maybe we should learn from these last years so that we can create what will really be what we need and be sustainable. So that's what I'm interested in, and I have a whole bunch of other thoughts, but they're not formed yet at all.
Well, I'm gonna. Do you mind if I blend in here, Todd? Okay. Um, that was sort of a question that came up today, actually, Sheila, was this notion that I kept saying, look, it's a systemic thing. We have to sit down as a group, the RDAP, or at least a subcommittee of the RDAP, if it doesn't want to be the whole RDAP, whatever. Some legislators, probably the attorney general, or, Todd, you would need to be really up on where she's at, I guess. And we need to sit down and actually throw everything out and sort of say, okay, where in the system do there need to be interventions and changes? And there was actually a fair amount of willingness to do that. And I think that that dovetails with what you're saying, Sheila, because there have already been revisions to the enabling statute. I mean, I don't remember the number or what, but Todd, whatever it was that took away the sunsetting of this body, it was in there.
Yeah, I think that was just maybe 3 years ago,
Right.
2021,
Something
something
like
like
that.
that. Yeah.
And so I just wanted to dovetail that with what Sheila was pointing out, because to me, it's a very natural outgrowth of that.
Yeah, thank you, Sheila. Any other thoughts, reactions from the panel?
That would be no.
Yeah. So let me throw the straw idea out there. Running with what Sheila was saying to some extent, and maybe I guess the first thing Sheila said, which I think is one of the more important ones, which is like we need to take time to think,
Right.
and really be creative in imagining what the future could be, and then recognizing, right, we've still got to engage with the legislature on how that future can look, given that they created us. And my recommendation is just to suggest that a smaller group put together a proposal for this panel to consider at the June meeting, so that we kind of create a structure. We make some suggestions around not only maybe just the system of how RDAP wants to be structured, meaning not this is what RDAP should do, but this is how we should talk about and figure out what RDAP wants to do and be. And along with that, some kind of structure for how we want to identify our next chair. Not who it is again, but what is the system we want to create? What are the steps we want to take to identify individuals, to what are the characteristics? I sort of, in a very simple way, think of it as almost a job search, right? We're looking for a director, somebody who can fill some pretty big shoes. So that's kind of my just pitch out there. And yes, Susanna, that's a great additional point. I'm going to turn my camera off real quick and move out of the room I'm in, but I'll still be.
Yeah, that's really true. Our absent members, yes. And I can imagine that some of them would very much want to be part of this group, that to do that. Meaning this isn't a really good night to put this together, is it? Shocker.
That's a fair question.
Let's Okay, we're on a bit of a slower time frame here. Todd, I think that's going on the agenda for next month. Is he was there, but I thought I heard him. The idea that what would be on the agenda for next month would be to construct this smaller committee, the subcommittee. That's all I'm saying. So
a time
repeat.
to have a subcommittee to do what though?
It's not only to figure out a way to pick the chair, but also to decide that about having this committee to sort of put out some very basic ideas about what this panel should be doing.
What are we doing right now with the time that we have? Because if we have time right now, I would love to start with just a brainstorm from this group. And if we think we need to form a subcommittee to be able to get more in depth, that's cool. But I would want to go back to the whole group anyway. So
Sure.
if we're all here right now, maybe just like bullet point brainstorm, pop out if you have anything that wants to be considered with that. Like
Yeah.
because I'm sort of curious, like if you talked about how are we gonna do this, like obviously we need names, right? So
Right.
can we talk about just right now, like how we want to get those names so we can figure out how to get the names and not be like, oh, is there a policy or structure? You know what I'm saying? We can just
Yeah.
start names to people just to get the basic stuff out too would be great if we have a little bit of time just to get us started on it.
We do. We do. Go ahead, Todd. I'm trying not to take over, but
I'm also running into the fact that I'm trying to capture what Sheila just said in the minutes while thinking about what we're going to do next. So no, it's totally fine. I'm to me, that makes the most sense is to sort of, and again, if the group doesn't pull it together perfectly for June, we still have food for thought. We all engage. I think folks will take the time over the next month, independent on a dog walk, on the commute, to start thinking about what does it mean? What should we be doing? What do we want to look like? So I have very little doubt that, the panel will engage. And my real hope is that we just put something out there for the panel to react to, and through that process come up with something that we think will work well, both for imagining our future and imagining our leadership. So, and to Susanna's point, I don't think we need to limit how many people. So reaching out to the folks who aren't here, I think can just be I'm happy to do that once we've got, at least a
right.
couple people from here. Sorry,
Susanna,
Susanna, go ahead.
Yeah, I think also, I guess I'm looking at it as multiple tracks. One is the structural and procedural course that we're going to take going forward, which I think is important, and looking at our charge and our membership roster. And then, well, maybe not, yeah. And then the other part that I'm seeing is the substantive stuff. What are we focusing on? I appreciated the refresh on the enabling statute because it reminded me, and I go back to my enabling statute often, and I often say to myself, ooh, yeah, about that, right? So I think getting that reminder is really important. And so one thing that I'm hoping might be able to come out of this summer's work is if we could come up with some kind of, I suppose maybe a priority list or a collection of focus areas, because the name of this group is broad and it carries a lot of really broad stuff, and it's difficult to divide our attention between all of those different topics. But I think perhaps if we were to say as a group, hey, here are the 3 things that we're really going to focus on, and that might be youth detention centers and I don't know, conditions of release and language access in the jails. I'm completely making that up. But if we said maybe those are our top 3 things, then I think it will help us to focus I guess one example I have is that a couple of years ago, the legislature assigned the schools a report on how to use the cannabis business development fund. Why? Because it used to be illegal? I don't understand. It felt ill-placed. And so I think that perhaps we might be better situated to respond to those kinds of things if we had a clear platform we could point to say, perhaps 2025 and 6, we are focused on blah, blah topics. If it doesn't fit, you must have quit. I don't know. This is just me
Right.
spitballing, but maybe a work plan or a strategic plan or something.
Okay. Sheila, what do you want to do in these last minutes here?
No,
Just
I was,
bullet point some stuff out?
yeah, I was just wondering if any had some burning thoughts now since we're here and I could hear it from them themselves. And if
Sure.
not, I mean, we can go around the room and just pass if you don't have nothing or whatever, or we can just have people be like, these are my thoughts right now and I'm still thinking. But I'm just wondering if there's any thoughts from anybody.
I personally like what Susanna just came up with.
I agree. You know, structure is a good thing too. I know it seems like so it does sound like a good idea as well.
Yeah, and I would imagine that it doesn't have to stay the same year after year. It could be something that gets revised as time goes on. Just a thought.
I also like Susanna's idea of coming up with like a, I don't know, like mini work plan or strategic plan as a way to map out where we're headed, especially for the remainder of this year.
Then, I
So
would go ahead.
no, I was just gonna say, so like maybe that's what we can formulate a committee around. I'm not sure.
Sure. I mean, that would be. Go ahead, Susanna.
Yeah, I mean, I think not to get too silly here, but I don't know if this is two groups, right? I'm seeing them almost as distinct hemispheres.
That may be possible too. Yeah. And I think you should throw everything out on the table. I mean, I really think that's think as broadly as you can, you know. I don't know, we should have an ice cream social every month. Whatever. I mean, just put it out there. I mean, one of the issues will be I think invariably, and this someone brought this up very recently, and I can't remember who it was, that we during the session may need to meet more often. And that's a question that came up. It also got brought up in House Judiciary today that, well, if we did that, we'd have to find money to pay people. And I didn't even respond. I was just like, yeah, like that ought to be self-evident. But I would really encourage that kind of broad thinking, that holistic thinking. Because I think the panel is really at a crossroads. I think I've been fighting for 3 years because everyone wasn't, not you all, but the legislature wasn't quite getting it, that we're at a crossroads. Coach got it, Dick Sears got it, Martin got it, but nobody else was getting it. So for June, make a list. Literally, make a list. We started it here. Thank you, Sheila, for pushing in that direction. And we're going to go over those. Coach.
Hey, Tom.
Yes.
I think you're right on target. You know, this is the point of Disney Imagineering.
Right.
You know,
Right.
and I think that's the way we should, you know, approach it. You know, granted, you know, there are, you know, enabling statutes and what have you,
Right.
but those nothing is set in stone. You know, I mean, we didn't punch them out in granite. You know,
Right.
they're on paper. you know.
Right.
So that being said, uh, like you said, go have some ice cream or some smoothies, and sit down and come up with a vision mission,
Right.
for the next let's say uh, legislative session and a half. So that's 3 years. You know, um, and that's not a bad span of time, and in reality. So
Right.
just food for thought.
No, I think that's great. I think people should just start. Sheila, is that okay with you if we do that for June?
Hey, yes, I'm open to whatever needs to happen to make things happen.
Okay. Okay. Just wanted to make, because we were sort of riffing on you here. So
I'm
Well,
just
well,
offering,
it
just
fits
offering
into the
that's all.
sun on your face.
I'm sorry, Coach, say that again.
It fits to the sun on your face.
There we go. There we go.
got it.
Yeah, so no, I'm just offering my thoughts for us to figure out together what we would like to do. I'm not
Okay.
I'm not tied to necessarily any one idea. I
Mm-hmm.
think all of these ideas putting into the space have their place and could be really valuable.
Good. All right. So that's our homework for June. All right. We'll pass it on to those who aren't here. And if you see any of them, do encourage them to come to the meeting next month. Just give them a little wink, nod your head. Yes, Susanna.
So I'm sorry if I missed this already. I just want to be really clear. What is the action item that's required from us? What do I owe you?
List of bullet points that all pertain to directions of the RDAP
Okay.
in the future.
Okay. Ready for June.
Please.
Okay.
Hey, Tom, would you like those sent to you prior to the June meeting, or is that something we bring to the meeting
I
for
was just
discussion?
thinking, I think we should bring them to the meeting. I mean,
Okay,
it's really easy if I do it, but I might miss something. So let's
sure.
do that.
Okay.
Oh, Aton, can I
Yes, ma'am.
offer something else? If people are able to have it before the meeting, it allows potentially more time for some of us to be able to read it, to be able to utilize that time
Okay.
for the meeting. It'll be a 50-50, and the ones who are talking have read it, and the ones who haven't will be reading it while the other ones are talking. So it will.
Right, no, send them to me. I will forward them to everyone. Just write your own sheet, send it to me. I will disseminate. Is that all right? I'll take charge of that. Please. Okay, let's do that.
Sorry, Aton, I didn't mean to give you more work.
No, 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 it's fine. Thank you. Really, really, it's fine. I think that's what we needed, Todd. Am I right?
Absolutely. I think it's a great step. My only question is whether, to Susanna's point of kind of two spheres, if we also want any focus on what the leadership transition looks like, if folks are
Right.
we can roll that into the same or a parallel conversation. I think we had discussed potentially not meeting at least in July, if not July and August, both for scheduling purposes, because we're supposed to only meet 10 times a year, et cetera, et cetera. And that seemed like maybe a good time to do some of that searching for the future chair. So my one thought is, if there are other folks who maybe have been involved in searches like that, have ideas about how to ensure that we're getting the right voices, faces, names into consideration, that would be my suggestion.
Okay.
Do we have a current little jobby description thing or something that you could send us? No?
I'm not aware of one, because the panel elects the chair. We're supposed to just pull somebody out of our own ranks. So it's not, I mean, we could certainly work with the existing chair to create something like that. I think you're not wrong, Sheila, that giving people some understanding of what is
Yeah, that might
expected is
help, wouldn't
important.
it?
Yeah.
Yeah.
That's a kind of a problem.
Yeah, that is a problem. Thanks for pointing that out because, like, why didn't I ever write that?
Well, because you just went into the position that was
Oh, right. Okay. Thank you.
somebody before we even put somebody in that position. It should have been written.
Right. You're quite right.
Um,
And oh, you
now
know what else? I just forgot this. I had another idea. We need bylaws. We need a few bylaws. Doesn't have to be a book, doesn't have to be 40 pages, but we really need to kind of get that together, I think. So that's just another issue. We're throwing them all out here because gotta get them out. But that's another one. And that I would argue could be later. It's not as critical because we're functioning without them now. It's not like we're stymied. So, you know.
right. But so right now, all we have to work off of really is an enabling statute to sort of describe what the panel is and to infer what a chair might do of just common sense chair stuff, other than like specific experience yeah. Yeah,
Mm.
so I'm just like, I'm trying to figure out like if we're gonna put it out there, then we need to figure out how, what are the honest tasks, Aton? And I guess, I would lean on you in this for obvious reasons.
Yeah. Yeah.
What maybe that's one of your outgoing roles is
Yes.
to just create like
A
and to
job description.
yeah, and to be realistic about what the time commitment has been for you. And
Okay.
I think that what's interesting about this panel, correct me if I'm wrong, I don't think in the statute there was anything about testifying, was there? And I think that was part of maybe people's points about our connection with the legislation. And so, I know that either Aton on our behalf or other members from here are encouraged and do, whether through their state capacity or their personal capacity, testify. And the point that I made before is we're doing a lot of work that isn't in that statute. And if
Right.
that is what we feel needs to happen, make that happen. So my point in saying that is I would love to see like a little bit more lack of better terms, itemized. I've been dealing with a lot of financial stuff lately, so and so I've got that's the word that's coming to my head right now.
I
But
get it.
like to be like, testimonials have cost me between driving, testifying, going home, whatever, this amount of hours. I would love
Yeah.
to see it broken up in sort of that way. So as this panel is considering what we will do or can do moving forward, then or want to do, then we can be like, yo, this is what it might take.
Right. Right.
Just want you to be real about that.
Right.
Before like be realistic about stuff so we can be honest and be straight. So
I will work on that as well.
thank you, Aton.
Absolutely. My pleasure. My responsibility, really. I mean, as well. So, okay, everyone looks really happy and thank you, Todd. You got everything you need? Good. Is there any public commentary? Okay, seeing none. I think I put new business down there as kind of a joke, given what this discussion. Oh no, hold on. Mr. Delos has to ruin it. Go for it. Ah,
It's more of
got
an
you.
announcement. It was more of an announcement than new business. I apologize. I just want to check with folks. If anybody has additional candidates for the note taker position, please send them to me. hopefully by the end of this week, I want to start talking to folks next week just to get that process rolling. So just a quick plug, more of an announcement, not new business.
Okay.
I just want to say that we put out a social on our social media, and hopefully maybe some people have contacted.
Yeah.
Will contact you.
Great idea.
Thank you. Thank you. Thank you.
I
Great.
have one other thing,
Yes.
an announcement, if this is the time. I might have mentioned this last meeting, but our Vermont Police Academy graduation is happening on the 30th of May, which is a Friday, from 10 to noon at the Academy in Pittsford, Vermont. And anyone and everyone is welcome to come witness kind of the culmination of 17 and a half weeks of really hard work for our future Vermont law enforcement. So, yeah. If you have any questions, reach out to me.
Thank you. All right. Our next meeting is on the 10th of June. And of course, I'll send stuff out. And I don't think we'll take a vote to adjourn because everyone's face is let me the hell out of here. So I will see you all next month. Love you all dearly. Be well.